This routine surgery went horribly wrong. But the doctor argues in his defense that he's never had a complication like this before, and as a result, shouldn't be held accountable for it happening in this instance. Number one, can I object to that when he says this at trial? And number two, can I prevent the doctor from ever telling the jury about this at the time of trial? You want to know the answer? Come join me for a moment as I share with you some remarkable information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. The doctor said it was supposed to be a routine surgical procedure, but during the course of the procedure, something horribly went wrong, and you, the patient, suffered horrible injuries, and you needed corrective surgery, and you were in the hospital recuperating for weeks on end, and you got complication after complication. Now you bring a lawsuit against this doctor, and during the course of the lawsuit, I have an opportunity to question this doctor, to find out from him what he did and why. And during the course of my pretrial questioning of this doctor, I ask him a series of questions. And he tells me, as honestly as he possibly can, I've never, ever, in my 20 years of practice, had this type of complication before. And I begin to realize immediately that this is the defense that they're going to use by saying, hey, this is a rare complication, I've never experienced this in my career, and I've never seen it either. And now he's going to try and use that at the time of trial to basically hold his hands up and say, hey, don't blame me. This is a routine procedure, but this is such a rare complication, nobody ever sees this, and I certainly have never seen it. Can I prevent this doctor during pretrial testimony from saying this? The answer is, no, I can't. In fact, I want this information. I want to know what the doctor's defense is, what it's going to be. The mere fact that a doctor is using the defense by saying, hey, this complication has never happened to me, therefore, don't hold me accountable for it, that does not allow him the ability to absolve himself of his own carelessness. And that I have to be able to show to the judge through our legal research. So now, if the judge agrees with us, that means that his attorney will not be able to use that defense at the time of trial. Even if the judge does allow the doctor to talk about it, I will then have an opportunity at trial to cross-examine the doctor and get him to admit and acknowledge that merely because he has never encountered this complication before doesn't mean it wasn't without negligence, doesn't mean it wasn't because of carelessness of the doctor violating those basic standards of medical care. So I'm still permitted, even if the judge allows his attorney to question him and to use that defense, I can then cross-examine him on the fact that this doctor never should have been in that area and this injury never should have happened. So why do I share this terrific information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in the state of New York. You know, I recognize and I realize you're watching this video because you likely have your own questions. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have legal questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, there's something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.